And Seth, if you would please introduce today's speaker.
Good afternoon, folks. Thanks for being here. My name is Seth. I'm the executive director of the association. We're grateful to have you here. We have a good program today. We have the amazing Maya Schulman, who is going to be giving us a case update regarding surrogacy law. Maya is the founder of Schulman Family Law Group. She offers legal representation to those in Los Angeles, Ventura, Santa Barbara counties who are dealing with issues of family law, including divorce and custody. Her many years of working with complex, difficult family law matters prepared her to handle complicated matters of move away cases, interstate and international family law cases. She has a deep commitment to confidentiality and discretion. Ms. Schulman often handles complex matters of custody, surrogacy, and entangled divorce for residents throughout California. So with that, I will just pass it on to Maya. Thank you so much, Maya.
Of course, my pleasure. Everybody, thank you so much. Thank you for coming back and spending your lunch hour with us. And back to my favorite subject, and that is surrogacy and adoption. But today we're talking about surrogacy. So the PowerPoint is presented. I'll do my best to manage it. You should have copies of it for the MCLE credit. And so without further ado, as they would say on TV, here we go. So I know that there are family attorneys here today and non-family attorneys. And why surrogacy? Why California? As I said the last time at the last presentation, California is and has been the friendliest surrogacy state of all, including the territories. And that's why people come to California to engage in surrogacy proceedings and fertility treatments. So California, because it's so friendly, inclusive eligibility. Singles and unmarried couples are welcome. LGBTQ plus friendly individuals are welcome. International intended parents are welcome. And California does not require medical necessity to be demonstrated to participate in fertility and surrogacy proceedings. We have statutory framework, which many other states do not have. And you will want to refer to Family Code Section 7960 through 7962. California also offers pre-birth parentage orders, which again, many other states do not have. They will have post-birth orders and adoption orders and confirmatory adoptions. But California does it ahead of time. So when the child is born, the orders are in place. And we have many decades of supportive case law that are making surrogacy available to so many people. And also the surrogacy contract is presumed to be valid. So those are all in place and available to surrogacy patients in California. Strong protections are available for compensated surrogacy. Many other states don't have it. Escrow requirements are protecting patients and lawyers and clinics and agencies as well. Everybody who is a party to a surrogacy contract has to have independent California licensed counsel. And we have privacy protections in court because pre-birth parentage orders are exactly that. They're parentage actions and they are confidential. So 7960 gives us definitions as to who the gestational carrier is, who the intended parent or parents are, who is facilitator, and establishes definitions for critical legal and financial agreements. 7961 talks about fund management by non-attorney facilitators. And the reason we want fund management is because, especially lately, and I'm not sure if you follow those cases or if you follow what's happening in the news, there has been a number of instances where agencies folded and they disappeared with patients' and clients' money. to the tune of $1 million. And those have become international and interstate cases where FBI is involved. They're trying to find the money, and the owner of the agency threw her hands in the air and she says, I'm sorry, my agency is now defunct. I cannot help you. I'm hoping insurance will cover it. And that's it. So the parents, intended parents, and surrogates were left abandoned and unattended, and there's no pathway to solve the issue. The money is gone, can't get it back. The embryos are still being frozen, and the patient's intended parents are left without a recourse, at least at the moment. The lawsuits have been filed. We don't know what's going on, but if you're interested in this, please do follow this. It'll be interesting to see what court does with this. 17962 talks about assisted reproduction agreements. And again, those agreements are presumed to be valid if properly executed. They authorize pre-birth orders to establish parentage. 7962, we talked about this a little bit, independent counsel, court filing, proper execution. Those contracts have to be attached to pre-birth order filings. So they become a part of the court file. And that's one of the reasons we want them to be confidential. We can get all this done pre-birth. Actually, halfway through pregnancies, that's when lawyers get involved. So the timeline is important, and I'll talk about timelines separately to give you an idea of how not quickly this process is supposed to proceed. The case that is important, and it's the landmark case, the family law case that came down in 1993. Most family law attorneys know this case, and the case is Johnson versus Calvert, 5 Cal 4th 84. The reason this case is so important is because this case established what's called intent to parent doctrine. In that case, involved gestational surrogacy, and that case is very different from another landmark case I talked about last time, the Baby M case. In this particular case, in Johnson versus Calvert, two parents engaged in surrogacy proceeding. The gestational surrogate had no genetic connection to the child. During the pregnancy, though, the relationship between the surrogate and the intended parents deteriorated, and the surrogate decided she wanted to keep the baby. The dilemma was that California law recognized two paths to the motherhood. One, it's the woman who gives birth, aka gestational carrier, gestational mother, and two, the woman whose eggs created the child, gestational mother. And in this case, the court expressed concern that there was economic coercion on poor women, that commodification of children and reproduction took place, and the psychological harm to the surrogates that forced them to relinquish the children. Also, the court was concerned with the possible lack of informed consent. EIK cannot fully understand emotional impact before engaging in surrogacy treatments. So, in this particular case, the California Supreme Court held that the Calverts, who were not genetic parents, but they were the intended parents, they prevailed in their quest to have the child. And the court held that when both genetic and gestational motherhood exist, but are divided between two women, the woman who intended to bring about the birth of the child for the purposes of raising it as her own is the legal mother. So the court reasoned in this particular case that intent is what is going to be the tiebreaker. So this particular case, again, is the key case to remember the new doctrine that is called the intent to parent, and it influences the subsequent cases when they come to path. Contract validity was also questioned, but the court held that the agreement was valid and enforceable. The court also found that there was no exploitation of the surrogate, and the policy considerations were satisfied by enforcing the validity of the contract. So the intent test, again, Johnson versus Calvert, that's the important case to remember for family law practitioners and for everybody else who wants to talk surrogacy. I will also remind you again that California is unique because it recognizes things that many other states don't. The next case that I want to talk to you about, also another case that an important case, is a family law case, but really has to do with surrogacy. It is Bozanka versus Bozanka, 1998 case, 61 Calap 4th, 1410. In this particular case, the married couple arranged for gestational surrogacy, and neither of them had a genetic connection to the child. Both the egg and the sperm came from anonymous donors. An embryo was created and implanted in a gestational surrogate, but before the child's birth, husband filed for divorce. And then he further claimed that he had no parental obligations because he had no genetic link to the child. The legal question in this case, because we're talking surrogacy, the legal question is, if neither intended parent is genetically related and the gestational carrier is not the mother under Johnson, who are the legal parent of the child? And is really this child going to be born legally parentless? Okay, so think of the words. We have a child who is born and he or she has no parents. What do we do? So the court in this case held that both Luann and John Bozanka were the legal parents despite having no genetic connection to the child. The court reasoned that intended parents, we now know the doctrine of intent from Calvert, and the court said the parents are legal parents because they intended to raise the child as their own. So here comes intent once again. And to make it a further point, because intent governs this dispute, genetic connection is not required. And public policy favors children having parents. So even though there's no genetic connection, the court wasn't going to leave the child parentless, and the court mandated that because they intended to become parents, they're going to be parents, whether they want it or not. And donors are not parents. Sperm donors and egg donors, by statute and by case law, are not parents of children. Okay, so this particular case established that California will enforce surrogacy agreements even if complete absence of genetic connection is present. So why is this case important? It is important because it now opens the door for LGBTQ parents, single intended parents, couples with genetic infertility, and it also opens the door for something that many other states don't allow. It opens the door for embryo donations. Okay, so these are the cases that I'm talking about first, and when we're moving on to, which I already alluded to a little bit earlier, pre-birth parentage orders. The benefits for intended parents are such that legal parentage is established before birth. The birth certificate is issued immediately, or as fast as the clerk's office gets to it, I should say. It gives intended parents medical decision-making authority. It avoids post-birth adoption. because in the absence of the pre-birth order, we have to confirm parentage via adoption cases after the child is born. So if we do it before before birth, then obviously it avoids having to do another filing after the child is born. It also establishes benefits for gestational carriers. It confirms that they're not responsible for the child they carry. It prevents confusion and it honors the surrogacy agreement, among other things. Legal requirements will be satisfied if GSA, which stands for Gestational Surrogacy Agreement, is executed before embryo transfer, and both parties have separate independent attorneys. Petitions are filed, attestations under penalty of perjury. Sometimes we also attach a fertility doctor declaration to that filing. And here's the legal timeline for you before I talk about medical timeline for you. So the process begins usually week 11, so not at the very, very beginning, although counsel should already be selected, the retainers should be signed, the conversations should have been had. So it's well on the way. And the order itself should be filed and finalized before third trimester of the pregnancy. So not in the very beginning, but not in the end, somewhere midway, it should be all established and it should all come to pass. Now, eligibility requirements in California. In California, gestational surrogacy should be between the ages of 21 and 40, so that they're mid-age. Pregnancy history, gestational surrogate should have had her own successful at least one pregnancy. Legally and financially, gestational surrogate cannot be on public assistance, cannot have criminal history, no convictions other than parking tickets, and those parking tickets should have been paid, no felonies, no misdemeanors. So there's going to be a background check. Many agencies also require fingerprints and criminal background check, not just a background check, but really in-depth criminal check. Parents in California, anybody, if you want to have a child, California allows anybody to have a child. Married couples, single individuals, LGBTQ, a little older parents, although ethically, and I've had those prospective clients contact me, ethically, I would not support people over 50 going through surrogacy treatments. That's my own opinion. Other lawyers may differ, but I think that having a child in surrogacy when an intended parent is over 50, I don't think it's a practically good thing for the child to be. So really no restrictions legally and lawfully in California. Also, California is different in that it allows donors to provide eggs, sperm, and embryos. Embryos are donated as a result of fertility treatments from couples who have extra embryos, because embryos can be disposed by clinics in one of three ways. One, they're used. Two, overage of embryos is given to research. Number three, they're donated to other people who are in surrogacy treatments, in fertility treatments rather. And lastly, if nobody wants them, or if intended parents don't want to donate them for any reason, those embryos are going to be destroyed. So, but the donation of embryos is allowed in California. Legal requirements for surrogacy agreements, we talked about this a little bit. Mandatory pre-execution. Content, you have to have in that agreement all the designations of who the intended parents are, of who the surrogate is. All the lawyers have to sign on to it. Execution and timing has to be done before medical treatments begin for the surrogate, and especially for if it involves egg donation. For before first fertility medication is administered, that's when the contract has to be signed, sealed, and delivered. Consequences for noncompliance. You have a rebutted validity presumption. You may have unenforceable contract. You may have insurance coverage disputes. You will have delays in establishing parentage, and more important than anything else, you will probably end up with having potential custody battles if the contract for surrogacy is deemed invalid. So back to the basics, you need to have an ironclad GSA, and that will avoid many, many problems. One other thing that I did not mention as a requirement for the surrogates, they have to be US citizens or permanent legal residents. Okay. The next section is Family Code section 7961. It talks about ESCO requirements, mandatory ones. So basic compensation, these numbers are for, on the left, you will see the base compensation for the surrogate. California, even though it's the friendliest state, it is also the most expensive state. And the numbers will speak for themselves. For the first-time surrogates, they get 60 to 70,000, although lately I know these numbers are higher. Experienced surrogates, which means it's not their first surrogacy, they used to get 85,000, but now, if you look here, I will tell you, experienced surrogate will ask and she will get over 125,000 for surrogacy. Additional compensation is going to include the numbers on the right. I don't need to go through them, just look at this. They're smaller numbers than the numbers on the left, but you will see that if it's a twin pregnancy or multiple pregnancy with multiple fetuses, the compensation, extra compensation goes up by between 5 to 10,000. If a C-section is involved for the surrogate, she will get additional 2,500 to 5,000. Now, these are all negotiations. These are not set in stone. These numbers can go up or down, usually more up than down. All of these numbers are paid by intended parents. The surrogate never pays for anything. Okay? So if you look at the total cost to the IPs, and IP stands for intended parents, it does not stand for Intel processor. IP in surrogacy language is intended parents. So IPs will have to pay out of pocket anywhere from 200 to 300,000 in California for one cycle of surrogacy. Okay. And I'd like to give you now a state-by-state comparison, which I think is very informative. And I only took a sampling of a few states. You will see I did California, New York, so we'll do bi-coastal state comparison. We'll take Illinois in the middle, Louisiana and Texas in the south. And let's look at California first and foremost. California is as friendly as it gets. You will see compensated surrogacy is allowed to single, unmarried couple, LGBTQ plus friendly. Here's the kicker. It does not require genetic connection to the child. It also does not require that IPs demonstrate medical necessity to engage in fertility treatments. So anything goes. As long as you have a valid gestational surrogacy agreement and the funds to pay for it. Let's look at Illinois. Still sort of friendly, not as much. Compensated surrogacy, yes. Single unmarried, yes. LGBTQ friendly, yes. Genetic connection now is required because at least one parent has to have genetic connection to the child. So it's a little bit more restrictive. It also requires that parents' IPs demonstrate a medical necessity for undergoing fertility treatments. If you look at compensation, California, the highest for surrogate is 125. Illinois is less. It looks like highest is 85,000. Now let's look at New York. New York, up to 5 years ago or so, had surrogacy deemed to be a felony. So whoever engaged in fertility treatments with the purpose of engaging in surrogacy was going to be charged with a felony if found out. That's New York. That's 5 years ago. Today, New York has decided it's fine. We can join the rest of the world. We will make surrogacy legal. Perfect. Now, compensated surrogacy is now allowed. Single, unmarried, okay. LGBTQ friendly, okay. Does not require genetic connection to the child, does not require to demonstrate that fertility treatments have to be medically necessary. Also, a little less expensive than California, but so is everything else. Let's look at Texas. Compensated surrogacy is allowed. Single unmarried people are in the discretion of the court. What that means is that they have to get court's pre-approval to undergo fertility treatments and engage in surrogacy. LGBTQ friendly, yes. Genetic connection with one parent is required, and medical necessity has to be demonstrated to undergo fertility treatments. That is Texas. It is much less expensive. We're looking at 40 to 50,000. Okay, that does not come close to 125 in California. And here's the kicker. Let's look at Louisiana. It is as red as it gets. Compensated surrogacy, not allowed. Single unmarried people, not allowed. LGBTQ, not allowed. Genetic connection to both parents is required. Also must demonstrate medical necessity for fertility treatments. Surrogate compensation is not allowed, which means that compensated surrogacy is off limit. Excuse me, it's limited. It's not allowed. And the only surrogacy that is allowed in Louisiana is the altruistic surrogacy, with an understanding that it's available only to married couples and nobody else. So if anybody asks you whether or not they should go to Louisiana to engage in fertility treatments, please tell them don't do it. Here's the process for surrogacy that includes medical treatment, including the beginning with consulting of agency lawyer to the very end of it. And you will see that the timeline for the whole thing is about a year and a half from beginning to end, between selecting the agency, matching with the surrogate, doing the background checks, medical evaluations, psychological evaluations, which are mandatory. You're going on to engage in counsel, doing legal contracts, onto medical prep, mock cycle, medications, embryo transfers, and all of that. So we are looking at about a year and a half to get this all accomplished. And now we will talk about the newer cases that come into surrogacy practice. Before we do this, however, I would like to remind, well, family practitioners know this, but non-family practitioners or observers, they should know that in California, in family law, embryos are considered property. All right, that's all. So if anybody comes to you for consultation, it is probably prudent for you to ask them if they have engaged in fertility treatments and if they have anything stored in the cryobanks. Because if they have, embryo donations and sperm donations and egg donations require a separate contract that has to be then incorporated in the judgment of dissolution. And this is where you really want to consult surrogacy practitioners because that is a whole different area of law and not many family law attorneys get involved in this. So we are at your service. Use us, call us, email us, do what you need to do. Also, just for fun, artificial reproduction technology has nothing to do with Picasso or Monet, but that's called art as an abbreviation. And lawyers who practice art, we call ourselves artists. Again, many of us cannot hold a brush, or if we do, we're not good at it. But we practice art, so we are artists. Excuse me. So let's talk about a few cases that came down not too long ago, not in any particular order. So I will start with Lepage, and if I mispronounce it, I apologize. That's the case that came out of Alabama Supreme Court. What I said before that in California, embryos are considered property. If you look at other states, you will know it's not the same in other states. Alabama is one of them. Louisiana is another one of them. So this particular case out of Supreme Court of Alabama, the issue in that case was, are frozen embryos children under the wrongful death statute? And before you read the holding and the significance of it, I'll give you the background of the case. So in this case, 3 couples engaged in fertility treatments, and they had their embryos stored in a cryogenic nursery. Okay. At some point in 2020, a hospital patient, not a surrogacy patient, but a hospital patient, wandered through an unsecured door in the fertility clinic and entered the cryogenic nursery. That patient then removed several frozen embryos. He got his hand burned by the sub-zero temperatures from the freezer. He dropped the embryos on the floor and killed them. Those embryos did not survive. All right. The plaintiffs in this case had previously contacted the center to express their concern that the clinic was not secured well enough in their opinion. So that was on the books. And what happened here, the issue for the Alabama court was, does Alabama wrongful death of a minor apply to extrauterine children? What are those children? Those are the children that are unborn, located outside of a biological uterus, such as frozen embryos. So the issue was, do those plaintiffs, do those parents recover punitive damages for the death of cryogenically frozen embryos? So in plain language, does that equate frozen embryos to children? Or are they just that, frozen embryos? So the trial court in Alabama dismissed the wrongful death claims, holding that the wrongful death of a minor applies to all unborn children regardless of their location, including embryos stored in cryogenic nurseries. And that's an important holding because it's very different from what would have happened in California. In California, frozen is frozen. In Alabama, it's not. And neither it is in Louisiana. So Louisiana and Alabama expressly hold that frozen embryos are equated to the status of children, and they can sue through a guardian, but they can sue. So that's one case that is of interest, at least to me, on that issue. And again, in my mind, it's not really a family law case. It's more of a frozen embryo case, aka surrogacy case, but I think it's interesting. So next case I would like to talk to you about is this one at the bottom to the left, CC versus LB, the 2024 case. That is a California case. And that case has to do with a sperm donor who terminated rights via adoption, later seeking parental status. And that case, in short, enforces the proposition that adoption permanently terminates parental rights regardless of a post-adoption contract. So in this case, CC, who was a sperm donor, provided sperm to a married lesbian couple through a written donor agreement for IVF. The agreement expressly stated, as it should have, that CC, the donor, will have no parental rights whatsoever, and that he, the sperm donor, will have waived his parental rights for a step-parent adoption. In exchange, the agreement provided that CC, the sperm donor, will have had substantial and continuing contact with the child, including weekly visitation and annual vacation time. And then, less than a month after the child was born, CC signed a consent to adoption. For 11 years, CC exercised visitation, and when the child was nearly 12, she no longer wanted to visit the sperm donor, and after the failed attempt to resume visitation, CC then filed a petition to establish himself as a presumed father. Okay, so the issue was, does a sperm donor who voluntarily terminated his parental rights has a standing to establish presumed parent status? And the holding was from the Supreme Court that absolutely not. The court affirmed the trial court's order granting motion to quash CC's petition, holding that the gestational surrogacy agreement was valid and that the sperm donor's parental rights were permanently terminated. So that's another important case that you should remember. And that brings us to the case of EF and GH versus Cooper Surgical. In my mind, this is really not a family law case or a surrogacy case. This is more of a case that has to do with product liability and contractual issues. So if you haven't read the case, you may want to look at it. I think it's a very interesting case. It's a 2024 case, again, out of California, LA specifically. And in this case, the plaintiffs underwent assisted reproduction technology services to have biological children. And in 2023, embryos were created, including sperm and egg in the Los Angeles clinic. And all of a sudden, all embryos unexpectedly stopped developing. And by day 5, they failed to reach the blastocyte stage. The fertility doctor then informed the plaintiffs that other clinics experienced similar outcomes and identified defective embryo culture media that was manufactured by the defendant, Cooper Surgical. So really, this has nothing to do with the IPs or the surrogate or the embryos. It has to do with the defective product that facilitated the destruction of many, many embryos because of the defective culture in which embryos were supposed to grow. So plaintiff brought 5 causes of action. Again, none of this have anything to do with family law or surrogacy in itself. The 5 causes of action were strict product liability design defect, strict product liability failure to warn, negligent failure to recall. And the relief they sought were non-economic damages, past, present, and future economic damages, punitive damages, costs of unit, costs of suit, pre-post judgment interest, and other relief that the court deems just and proper. Again, none of it has to do with family law or surrogacy law in itself. So the significance of this case for surrogacy is that this product liability case raises critical questions about quality control standards in the fertility industry. I'll take a little segue here and I will remind everybody that in the US, surrogacy and fertility industry is not regulated on the federal level. There are no laws on the books that will tell you what is not, what can, what cannot, what should and should not be. Federally, it's not regulated, which is different from many other countries. State laws exist and they differ from one state to the next. In this case, it's still ongoing and it's going to go for probably a few more years because the damages are significant in sense that the embryos were destroyed. And I'm not sure what dollar amount you can put on families, many of whom cannot have any more children. This was their one chance to do it. So all of the embryos were stored at that particular facility, and a number of them were permanently destroyed. You can't resuscitate an embryo. Okay, so that's another case that you want to know about and think about when you talk about fertility and surrogacy. And then we have another case that actually was just published today by, not published, I would say, but discussed by Judge Goldberg in his email blast when he talks about new cases that come down. This case that's on your top left is FAM versus Superior Court 2025 case. Judge Goldberg did a great discussion of this case, and this case has to do with frozen embryos and particularly frozen embryo disposition upon divorce. So as I've said before, in California, embryos are considered property, number one. Number two, surrogacy agreement is presumptively valid. And the holding in this case was exactly that. It reinforces that courts will enforce clear contractual terms for embryo disposition. Now, surrogacy fertility patients have at least 4 different contracts that they have to deal with during the course of their fertility treatments. Number one, there will be a contract with fertility clinic. Number two, there will be a contract with a sperm donor or an egg donor, depending on how that particular surrogacy process goes for that individual or couple. Number three, of course, there's going to be a contract with a surrogacy lawyer. Number four, there's going to be a contract with a clinic. And for all of those things, you need to consult with artists, lawyers who do surrogacy things. There's a bunch of us in town. We're all accessible. We all like to talk. Clearly, you look at me. And we will talk to you and we will tell you and we will advise you should you reach out. So this case, again, Judge Goldberg did a good summary of it. Please look it up. There will be more cases coming up. I think it's going to be highly litigated. I do know from experience that there are law firms in just Los Angeles that specialize. They don't do anything else. They only specialize on cases that deal with um, breaches in surrogacy practice, breaches in fertility treatments, breaches in clinics and cryopreservation bank conduct, like the copper surgical. Copper surgical, I think, is now defended in more than one case for sure. I'm not sure if it's three or more, but I know it's more than one. So, like I said, there are firms that do only that. So that'll give you an impression of how widespread this issue is in California, but it goes outside of California. The clinics are being sued and the manufacturers are being sued and cryobanks are being sued a lot, and there's a reason for it. So key takeaways: California surrogacy law. In California, intent to parent is key, protects all families. We talked about cases earlier today. Genetics is not required. Statutory protection in California, statewide, 7960, et cetera, et cetera. Independent legal counsel, ESCO requirements. We do offer pre-birth orders. If not, we can do post-birth order by way of adoption, and that will be a confirmatory adoption. Inclusive eligibility, anybody's welcome. No medical necessity, donor gametes are permitted. No residency required, and that's a big one. This is why people come to California. It's called surrogacy tourism. All right, everybody's welcome. National leadership, we talked about this as well. Action items for your practice. R&R. It's not your typical R&R, right? R&R in this context stands for review and revise. Make sure that your templates comply with the code. Timing is critical. It has to be done before embryo transfer. Independent counsel, ask for compliance, stay current on the law. Interstate awareness, and the best example is make sure you advise your clients, do not get involved with states like Louisiana and Alabama. All right. And that is really my presentation for today. I think we have about a few minutes left for questions. There's something in the chat.
Yes, there is. Someone made a comment in the chat. If you could advise, what is the source for surrogacy requirements?
The source for surrogacy requirement is the Family Code Section 7962, which just I said. You also may want to look at the ABA guidelines. Remember, there are no laws that will tell you what to do, what not to do, but ABA has a subsection, subchapter, if you will, for art attorneys. And those requirements are published in ABA sections, and they're also in the code. You go to Family Code for the guidelines and the bullet points for what the surrogacy agreement has to have. I teach this in the law school, and I teach exactly about what the contract should and shouldn't have. And I'm happy to talk to you about this offline, but you go to the statute first. And the source for the surrogacy requirement and surrogacy contract is in the code, but really requirements in California are none. Assuming you have a couple or an individual who cannot get pregnant on their own after a year and a half of having unprotected sex, that would be your first requirement to try to explore surrogacy and fertility treatments. Other than that, it's really your wish. Many people nowadays, I see the comment. I'll respond in just 1 second. Especially for people who want to get this done, there are no prohibitions. So requirement for the surrogate individual, for the surrogate, they cannot be on public aid. That is not in the code. that is practice, that are practice points. I don't believe the code gives this limitation. So that is something that they have to be financially independent because compensation for surrogacy to a surrogate is taxable, right? That's work, that's taxable income. That is not a gift, that is not a grant. They get paid for it in California. They're compensated, so they cannot be on public assistance. Does that answer your question? Okay, I'll
Great.
take it as a yes.
All right. I had a question. When does the obligation of the intended parents to the surrogate end? What if there are complications after the birth down the line? How long must they cover, say, with their medical insurance? Is there an end date that happens after birth, or is it ongoing?
It's not ongoing. There will be an end date, and it will be in the surrogacy contract with the surrogate. Okay, all of this has to be negotiated. This has to be negotiated. Also has to be negotiated if something happens to the surrogate during labor. If surrogate is on life support, what happens to the baby? Surrogate will have to have life insurance. All of this has to be there. Um, Surrogacy contract controls. And that's why it is so important that lawyers are involved on both sides of it because that's negotiations. We have a list of what has to be negotiated, right? When do you terminate a pregnancy? Who has the right to terminate a pregnancy? Do we give the surrogate the autonomy over her body when and if we talk about terminating a pregnancy of the child she's carrying? All of those are huge questions, right? So let me just answer this question. You stated a number of requirements for the surrogate, like age. So what's the source of this? The source of this is practice and pointers from the ABA, not in the code. Like I said, there's not a textbook necessarily we have, other than practice pointers from other lawyers who do this and who've done this for years. The age requirement for the surrogate, that is something that has to be guided by the fertility clinic. If the surrogate is too old, she cannot carry, right? That's a medical issue. That's not a legal issue. So you will go to the clinic for that guidance. And the clinics tell us that the surrogate has to be between the ages of 21 and 40. Because if the surrogate is too old, those who carry children, it's a major trauma on the body. So the older the surrogate is, the more problematic the pregnancy becomes, and the more exposure fetus has to problems. You want to have a healthy child and a healthy fetus, and you don't want an old surrogate to do this. That's where the requirement for the surrogate age comes from. It comes from the doctors, it comes from the clinics, not the lawyers. We don't command it. We follow the guidelines from medical professionals on this. That's why there are so many people involved in one surrogacy contract because you have to connect the dots from all angles: legal, medical, ethical, all of the above. So that requirement comes from a medical consultant.
Great.
I would love to add it to the materials, but my hour is up. So,
No,
and I've been talking for an hour, so I'm happy to do this. San Fernando Valley Bar needs to guide me on this. I'm happy to add more of this and all that stuff. So my contact information is, Linda, you want to put my contact
right.
information?
They could email me and I could put it in we could send out an email. Yes,
All
no
right.
problem.
Okay.
We'll have the contact information go out. And just one quick question also with your practice, how many of the surrogates do have their own legal representation? Do you
All of
advise
them.
them? They all
All of
do.
them. All of it. This is non-negotiable. All of them. All of them do. Absolutely. Um, I didn't think of this. I should have advertised myself in this presentation, but I didn't. So, but thank you though. Every surrogate has to have legal counsel. This is non-negotiable because if they don't, you're just waiting for a malpractice lawsuit. It's not worth it. So everybody has to have counsel. Lawyers exist for a reason. I tell this to all my clients. We have a reason for existence, so use us.
Great. This was so informative. Thank you so much for your time. We'll get out your contact information to everyone. And thank you all for spending the lunch hour with us. MCLE will be going out later today. Thank you again. Terrific presentation.
All right. Thanks, everybody.